We need a little bit more drilling down. So let's bring on another expert, constitutional lawyer, Jeff Lewis. He's in Los Angeles for us. So, Jeff, today is not about Roe v. Wade, is it? For people thinking, oh, the Supreme Court is going to take on abortion. That's not really the case. What are they taking on today?
What they're taking on today is the power of the state legislature to insulate a new law, a controversial law, from federal court review. And what's in play is more than just abortion rights, but substitute guns, voting rights, any controversial issue. That's what's in play this morning.
Texas did something very novel. They developed a workaround, basically, right? To say, all right, listen, this is something that we can now we're going to make the citizens the police force. You can be exposed to lawsuits through this workaround. And it's pretty ingenious, is it not? In terms of, here we are. Now the Supreme Court's going to weigh in. What are you listening for here today, and as we listen to these arguments?
I'm going to be listening for questions from the conservative majority as to whether or not this fiction that there's no state involvement is really real. So, for example, clerks and judges have to enforce this law in the sense that they issue summons and they can impose damages on private parties. If the conservative justices are asking questions about state involvement, I would suggest that the court is going to accept the notion that they can review the constitutionality of this law.
And for people that are thinking that this does have ramifications for Roe v. Wade, it may not, but it really isn't about Roe v. Wade, is it? This is about this other mechanism, this other novel sort of system that Texas has introduced. Roe v. Wade is coming with the Mississippi case.
That's absolutely right. I don't expect the court, in its opinion on this case, to make any grand pronouncements about whether a woman still has the right to make medical decisions about her body or the limits of that constitutional right. That's not going to come until a later decision in December. Today, we're just going to be talking about the power of a state legislature to design a law to evade federal court review.
Do the conservative justices, to your point of, you're going to be listening to their questioning, their line of questioning, where do you think they're going to land on this one? Because this is kind of it's a way to take power almost away from the Supreme Court to dive in on constitutionality in terms of the logistics of suing and whether or not you can go after a state. Where do you think that half of the court is going to weigh in?
It's an interesting question because at first blush, one would say, well, with 6 conservative justices, they're going to look for any avenue to avoid answering this question of abortion and avoid hearing this case. On the other hand, a majority of justices agreed to hear this case on this procedural question. So I do expect this to be a close case, and I do expect at least one conservative justice to, in an opinion, write about the ability of federal courts to intervene in a case like this.
Yeah, it's going to be fascinating to listen to. We're going to step aside and take a break. When we come back, we'll talk more about this case and what we should be listening for at the top of the hour. Again, Jeff Lewis is a constitutional lawyer, and he is from Los Angeles. Also with us, Sue Ann Robinson. She's in Fort Lauderdale, Florida, and she's been with us all morning. Jeff, this case was taken up with such speed by the court since Bush v. Gore. The court has not reacted in this way. What does that tell you?
It tells me at least a majority of the justices recognize that there's now, in effect, a complete and total ban on abortions in Texas, and this needs to be addressed quickly in terms of this new structure of this new kind of law.
Jeff, the court has reacted quickly on some level. However, they declined to enact a stay in the law, and that was controversial, a 5-4 decision. What did you read into that? The fact that the court said, we're not going to stop what you're doing, Texas. We're going to talk about it in a few weeks, but go ahead and keep doing it.
Well, on one level, the text of the order denying the stay said, we're not ruling on the constitutionality of the law, so don't read anything into this. But the practical effect is, by not enacting a stay, It's a clear signal that the majority of justices on the Supreme Court are poised to overturn Roe v. Wade.
And Jeff, to that point, if this is, if it's allowed, if you will, allowed, this could be replicated with different subject matter. There could be a state that down the line says you can't wear yellow on Wednesdays, or you'll be sued by your fellow citizens, and you can't do anything about it. That's the point here, and that's what this court has to grapple with.
That's absolutely right. Substitute guns, gay marriage, religion, voting rights, any hotbed issue for abortion. And those are the issues at stake here. The real question here is the fundamental power of a state legislature to avoid federal court review. And that's what's in play here today.
Yeah, and many people would argue the state should have power over the federal government. And if you don't want to live in that state, you don't have to live in that state. You can move to another state. And that the state's rights are at stake here, but it's going to be fascinating because it is a very novel argument, a workaround, if you will, that the state of Texas has come up with. And today, the United States Supreme Court will hear those arguments. Welcome back to the United States Supreme Court. It's just moments away from hearing arguments around a restrictive Texas abortion law. The justices are hearing cases, two of them. One was filed by abortion providers, Whole Women's Health versus Jackson. The other by the Justice Department. That's the United States versus the state of Texas. The issue in front of the court is whether abortion providers or the Justice Department can mount a federal court challenging the new Texas law. Jeff Lewis is with us. He's a constitutional lawyer. He's in Los Angeles. And Jeff, forgive me if I cut you off. As soon as they begin the arguments, we'll go in and listen to them live. But for our viewers that are going to become listeners here in about 2 minutes, what should we be listening for in terms of getting a sense of where this court is leaning? You mentioned that you're going to be focused on the conservative justices. What about the entire court? Because this is, again, not all just about abortion.
Right. And also one of the issues in play is the institutional power of the court and the presidential power of decisions that have been around for 50 years. So one of the things I'm going to be listening for are any justices that make comments regarding the power of precedent and whether or not this is an appropriate to challenge a case that's been on the books for nearly 50 years. Those types of questions.
What give us a sense of what it is like to be, arguing these cases. These are heady issues. These are constitutional lawyers that they can, there's a lot of work that goes into today. Safe to say the individuals appearing before the court today are pretty tight. This is a sleepless night beforehand because these justices are pretty intelligent men and women that just pepper you with questions.
Well, you could expect these attorneys to be very well prepared. They would have done practice arguments with other lawyers or judges pretending to take on the roles of Supreme Court justices. They will have answers that they've rehearsed and are prepared. So I don't expect any big surprises. None of these attorneys are going to be caught flat-footed. They will be very well prepared.
Yeah, and it's always fascinating to listen to the back and forth. Allowing the public now to listen live is really opened up the court, which before you'd have to travel to D.C. and get yourself into the chambers. This has allowed the public to kind of get a sense of what goes on in our highest court. Your thoughts about this, allowing us to listen live, and then maybe someday cameras?
Yeah, hearing it live is quite extraordinary. It's one positive development out of the COVID-19 pandemic. I don't think the TV cameras will be allowed anytime soon. The court has had long resistance to that. But having the ability to hear the tone of questions and not just read a cold transcript is remarkable. Hearing Clarence Thomas right out of the gate always ask the first question, as he's been doing during this term, really enjoyable to listen to.
Which we should point out. Clarence Thomas was the guy that never said a word before. He went years without asking a question, and then he has really changed during the pandemic. It's fascinating that the personalities of the justices, too, you can pick up a little bit in their questioning and sometimes in their frustration with the answers that they're getting or not getting.
Absolutely, yeah. You can hear the justices really press attorneys if they're not answering a question directly or in a way that satisfies the justices.
Yeah. All right. So for reminders, we're waiting for the arguments to begin. We're going to hear two separate cases, but they're basically the same case, arguing the same thing. The first is Whole Women's Health versus Jackson. This is the argument that a provider should be able to have to defend a lawsuit fighting the Texas law that enables citizens to sue providers. And the other is the United States government against Texas. So, Jeff, you're going to see, especially with the U.S. versus Texas, you're going to see some very seasoned barristers, or if you are you not, you're going to see some folks that know their way around this high court.
Yeah, absolutely. The participants in today's argument have been there before. They know what they're doing. They practice their arguments, and they will be prepared to answer just about every question. The only thing new is with this new framework, this new setup of how this law is structured, I don't know if they know what to expect the justices to ask in terms of state involvement in enforcement of this law. It's a new area, and we should see some fireworks there on this issue of state involvement in enforcement of this law.
And expand on that. What do you mean by that, and how should we be listening for it?
Well, look, if none of the 6 members of the conservative wing of the court ask any questions about clerks and judges being the arm of enforcement of SB8, then you could expect that this case is going to go down in favor of supporting the existence or validity of the law, that they will find that there's no jurisdiction to hear this case. On the other hand, if you hear important questions like, isn't it true that a state judge or a state clerk has to compel parties to come into court and defend themselves, and isn't that a real consequence that the federal court should be involved in? Then there's a glimmer of hope that one of the 6 conservative justices is going to find that there's state action here and that the court has jurisdiction to hear the case.
All right, let's go in. The arguments have begun.